Welcome to Office Gladiator, your source for all things legal. Don't forget to like, share, and subscribe to our page for more legal insights and advice. Today we're embarking on an enlightening journey through the life and sequence of a felony criminal case. Felony cases might seem like a tangled web of legal jargon and complex procedures, but understanding them is crucial. Whether you're just curious, studying law, or unfortunately find yourself or a loved one involved in one, knowing what to expect can make all the difference. We'll be breaking down each stage, from the initial arrest to the final verdict, in a clear, concise manner, shedding light on what can often be a mystifying process. And remember, we also post videos about employee and employment advice, tips, and information for the workplace. Knowledge is indeed power. So buckle up as we delve into the complex world of felony criminal cases. A felony criminal case typically begins with an arrest. When law enforcement apprehends a suspect, they must read the individual their rights, commonly known as Miranda rights. This includes the right to remain silent and the right to an attorney. After the arrest, the suspect is taken into custody and booked, a process that involves taking their fingerprints and mugshot. Now, let's talk about charges. The prosecuting attorney reviews the case and decides what charges, if any, to file. This decision is usually based on the severity of the crime and the strength of the evidence. Next up is the concept of bail. Bail is a set amount of money that acts as insurance between the court and the defendant. If the defendant can post bail, they can be released from custody until their trial. However, they must adhere strictly to any conditions of release set by the court. Once charges are filed, the defendant makes their first appearance in court. At the arraignment, the defendant hears the charges against them. This is a pivotal moment in the life of a felony case where the court formally presents the charges. Now it's time for the defendant to respond, and they do so by entering a plea. There are three main pleas: guilty, not guilty, and no contest. Pleading guilty means the defendant admits to the crime. A not guilty plea, on the other hand, contests the charges, leading to a trial where the court will determine the truth. The third plea, no contest, is a bit more nuanced. By pleading no contest, the defendant neither admits nor disputes the charges. However, it's treated similarly to a guilty plea in terms of sentencing. So, at the arraignment, the defendant learns their charges, pleads, and sets the course for what comes next. After the plea, the case moves to pre-trial motions and hearings. The journey of a felony case continues. This stage of the case involves the exchange of information between the prosecution and defense. It's a crucial period known as pre-trial motions and hearings. Let's delve into what that means. In this phase, both sides employ a process called discovery to share evidence and information. It's a bit like showing your cards in a poker game, ensuring a fair play. But there's a catch. If either party uncovers evidence they believe should not be admissible in court, they can file a suppression motion to exclude it. Pre-trial is also the time for plea negotiations. The defense and prosecution might try to reach an agreement to avoid a full trial. It's a bit like bargaining, where the defendant pleads guilty to a lesser charge in exchange for a lighter sentence. But what if they can't strike a deal? Well, that's when the gavel gets serious. If no plea deal is reached, the case proceeds to trial. The trial is where the prosecution and defense present their cases. This is the stage where the proverbial rubber meets the road. It's an intricate dance of strategy, evidence, and persuasion, all under the watchful eye of the judge and jury. The trial kicks off with opening statements. These are like the appetizers before a meal, setting the tone and giving a preview of what's to come. The prosecution goes first, outlining their case against the accused. The defense follows, presenting their counter-narrative or defense strategy. Following the opening statements, the main course is served: witness testimony and cross-examinations. The prosecution presents their witnesses first. Each witness provides their account, after which the defense gets their chance to cross-examine, attempting to poke holes in the witness's testimony or credibility. The defense then brings their witnesses to testify. The prosecution takes their turn at cross-examination, scrutinizing the testimony for inconsistencies or falsehoods. It's a back and forth, a tug-of-war of narratives, as each side tries to sway the jury in their favor. Once all the witnesses have testified, the closing arguments begin. Think of these as the dessert, the final taste left in the jury's mouth before they deliberate. The prosecution and defense summarize their cases, emphasizing key points and attempting to tie all the evidence together. After the closing arguments, the judge provides the jury with instructions. These guide the jury in their deliberation, helping them understand the laws pertinent to the case. The jury then retires to deliberate, a process that can last from hours to weeks depending on the complexity of the case. The moment of truth arrives when the jury returns with the verdict. The court clerk reads the verdict aloud and the fate of the accused hangs in the balance. It's a moment of high drama, one that can bring a sigh of relief or a gasp of disbelief. Once the verdict is read, the case moves to sentencing. But that, dear listeners, is a tale for another time. For now, let's pause and reflect on the intricate dance that is the trial process. Sentencing is when the judge decides the defendant's punishment. At this point, the judge weighs all the facts of the case, the nature and severity of the crime, the defendant's past criminal history, the impact on the victim, and societal interests. It's a balancing act aimed at achieving justice. If the defendant is convicted, the judge decides on the appropriate punishment, which could range from a fine to probation to imprisonment. It's a moment of high tension as the consequences of the judge's decision can be life-altering. But what if the defendant or their legal team disagrees with the verdict or the sentence? Well, they have the right to appeal. An appeal is not a do-over of the trial but a review of the legal process. The appellate court checks for errors and decides whether the law was applied correctly. And that, in a nutshell, is the life and sequence of a felony criminal case. So, from arrest to sentencing, the process is complex and full of legal nuances. Indeed, a felony criminal case is like a long, winding journey, fraught with numerous stages and intricate legalities. We start with an arrest, where individuals are taken into custody based on probable cause. We then move to the charges, where the district attorney's office reviews the evidence and decides on the charges. Next, we have arraignment and pleas, the defendant's first formal appearance in court. This is followed by pretrial motions and hearings, where attorneys argue for or against certain evidences and testimonies. Then comes the trial, where the facts are presented and the jury decides on the verdict. Finally, we reach the sentencing phase, where the judge determines the punishment and appeals may be filed. All these stages are interconnected, each with its own importance in shaping the outcome of the case. Remember, knowledge is power. Stay informed by liking, sharing, and subscribing to Office Gladiator. Thanks for watching and see you in the next video.